Hi, good night, everyone. Sorry for the delay. We had a bit of technical issues, but I'm so happy that you're able to join us tonight for our webinar series. To just quickly introduce myself, my name is Laquan Smith, and I am the marketing officer here at Affinity Plus Credit Union. And just to do some quick housekeeping, you will receive the recording and a summary of this session after it is finished. And if you have any questions, just raise your hands. To continue to give a brief background on Affinity Plus, we are the third largest credit union on island, and we have three locations, one in Bridgetown, Oistins, and Spoitstown. Here at Affinity Plus, we do everything with a A+ approach, and we have various products and services such as loans, savings accounts, and we also have a savings account specifically for our education, as well as retirement accounts, junior membership, and scholarships as well. And we also have a Smart Youth Leaders Club. In regards to that Smart Youth Leaders Club, we also have an upcoming webinar on Saturday the 1st, where we will discuss navigating the shift from school to the world of work. Now, I guess all of you may be asking, why are you here tonight? Well, we are here tonight to discuss the topic of estate planning and securing your legacy via a will. Some of you may ask, why is this topic important? Estate planning is important because it determines who your assets go to. By law, if you don't decide where you want your assets to go, the government will decide for you. And it's also important because it puts processes in place to take care of your kids, dependents, or any pets, for any pet lovers out there. And also is good for any situation. For example, we always hear of stories where a relative will pass away, and then all of a sudden a long lost relative turns up and claims the house and decides that is theirs. So it definitely helps to avoid those types of situations. Without further ado, before I introduce the host, he will cover a whole set of topics. For example, what is a will, the different types of wills, and how to actually create a legitimate will, and so much more. But to just give you a brief background on our host, Shazard Mohammed is the Chief Legal and Compliance Officer here at Affinity Plus Credit Union Limited. He was called to the Bar of Barbados in 2016 and Trinidad and Tobago in 2015. Shazard specializes in corporate and commercial law matters, having attained his master's in law in corporate and commercial law from the Cave Hill campus and legal education certificate from the Hugh Withing Law School in Trinidad. Having practiced at some of the leading corporate and commercial law firms in Barbados and Trinidad, he has a wide range of experience and specialization in various sectors from oil and gas law, and as well as employment and social security and public construction contracts. He has a strong acumen in reviewing and evaluating contracts, shareholder agreements, and various other corporate and financial documents. He is also a certified mediator in civil matters, and he is very keen in mediating and resolving matters in the best interest of all stakeholders. And finally, Shazard is also a member of the Green Committee of Barbados Chamber of Commerce and Industry. So as you can see, Shazard comes very highly qualified, and he will definitely be able to give you some more insights on creating wills and estate planning. And without further ado, I will hand over this tonight's presentation to Shazard. And don't forget, if you have any questions, just raise your hand. You should see a button at the bottom where you're able to raise your hand there. So just raise your hand and we will answer any questions that you have. Or if you want to wait until the end of the session, that's okay as well. So without further ado, I will hand over to Mr. Shazard Mohammed.
Hi, good evening, everyone, and thank you all for joining Affinity Plus Credit Union Limited in our ongoing educational series. Um, it is my pleasure to be presenting on um, basic components of a will that everyone should be aware of. I'm sure Laquan, in her introduction, you didn't hear estate planning, you heard everything else but that. But that is the nature of law in terms of your practice areas and your practice points. But I mean, it is something that every attorney, everybody should be aware of. And I always tell people education is important, and here at Affinity Plus, we really do share that sort of commitment to education. And so, therefore, without further ado, we can proceed. I just want to say to you that the presentation is our disclaimer to it is just for general advice. It's just to ensure that you have a basic understanding and appreciation. Affinity Plus will ask of you to seek any further specific legal professional advice from a duly qualified attorney at law here to practice law in Barbados. And any reference to masculine gender or whatever, it's not construed to be discriminatory. It's just for the presentation purposes. So when I would ask that you, if you do have questions, you could put them in the chat. I will have a brief interval between, or if there's a pressing question, Laquan will moderate. She's our moderator, and she's going to let me know with respect to um, any questions that may pop up. So the first thing we want to do is basically understand um, just the context of wills and just understanding. And I like to start with where you have a nice proverbs from the book of Proverbs. So where there is no vision, the people perish, but he that keepeth the law, happy is he. So a will essentially is that vision that you would have after you depart from this life, and you want to make sure that your will is done properly in accordance with the law. So whatever you leave behind, happy will be the beneficiaries. So that is something that a will provides. It's that vision that you have for whatever effects that you may accumulate in this life and how it is you'd like to dispose of it. And then the other quote I would like to share with you all is also from the case of Rowlands, and that where Lord Denning said, the whole object of construing a will is to find out a testator's intention so as to see that his property is disposed of in the way he wished. So, in light of that, you're getting a sense that a will is that vision that you have for all your assets and how you'd wish to dispose of it and the manner in which you wish to dispose of it written down for others to know and to understand. But there are certain laws that govern that. So, if we were to define a will is a revocable declaration in a prescribed form, and it's made in contemplation of death. Now, it doesn't have to mean that you make it at the point of your deathbed. You can do it years, because I mean, no man knows when the hour comes when we will depart this life. And therefore, it is good and proper planning that you do have a will in place, and it expresses the intention of the person making it regarding matters he intends to take effect after his death. And you, as the person making a will, we refer to you as a testator. So just remember that once you are making that last will, you are referred to as the testator. Now, a key point to remember what a will does is that it is a written document. It conveys the intention of you, the testator, it will only take effect on debt of your debt. It is revocable. And when I say it's revocable during your lifetime. So, in other words, you can amend your will, for want of a better word. And it's ambulatory, meaning that it will only take effect on debt and it will work its way after the point of death. Now, there are different types of will. There are conditional wills, there are joint wills, there are statutory wills, and there are privilege wills. Today, we are going to focus on a standard will. Conditional wills, as the name suggests, it's conditional on certain events happening. Um, Joint wills are usually made by a husband and a wife. Statutory wills are wills made pursuant to, say, a mental health application where you are made the custodian or the guardian or basically the ward of somebody who is not capable of making their own decisions. So it's a mental health application. And then a privilege will is one that is made by soldiers, those who go out in battle. So at that point, it's supposed to have that effect of ensuring that in a moment's notice in the line of battle, that a will preserves the intention of the soldier in battle, so to speak. So when you're making a will, I want us to focus on um, two things essentially. Now, your attorney needs to take proper investigations or proper instructions of your circumstances. What does this mean? It essentially means that your attorney is going to collect certain key documents. In the financial world, we call it KYC, or know your customer. So in this case, it will be know your client. So your attorney is going to ask you for certain proof of ID. If you are gifting a house, um, you might want to see title deeds. You have cars, you have houses, whatever. Louis Vuitton purse or something. You list down everything that you wish to dispose of in your lifetime to whomever you choose. And when you do that, it's a process. I always advise people, take the time, look at what you have, and try to give it a clear description, unambiguous description. So you have two Mercedes Benz in your garage, and one is red, one is blue, and they would both carry different number plates. So you need to be clear as to which one you're giving to your daughter and which one you're giving to your son. And all of that boils down to having proper drafting, which we'll return to. So it's to kind of build and start casting your minds as to how it is I go about drafting this will and getting everything that I need to dispose of to my attorney. So the drafting is done clear and unambiguously. Now, when you're doing a will and when you're making a will, just remember, and I always like to use this joke that doctors see to us at the point of death. After death, doctors, the most you could do is a post-mortem by a forensic pathologist, if necessary. But a lawyer's job continues way after you depart this life. And therefore, you have to make sure that certain things are in place. So your will, when you do it, it must naturally cater for whatever debts and liabilities that you have. So you owe a debt to a judgment debt. You may owe money to BRA, and all of these things are going to be settled out of your estate first and foremost. There will also be a revocation clause that you revoke previous wills that you would have done, because when you say you change your mind along the way, you didn't want to give the house to your wife, you wanted it to go to a charity, and therefore you will have to revoke that will, giving it to the wife, and now giving it to a charity. Just say you must have a residuary clause, and I'll go back. I will deal with residuary clause later down. There must be a proper attestation clause, essentially attesting to your signature, and you must have witnesses, and the will must be dated. Because if you don't have an undated will, if there's a will that pops up that has a date on it, the argument could be put forward that the will without the date was a previous date, and that's not your intention. You change your mind along the way. So, some of the things when you're drafting a will, and despite whether your attorney drafts it for you, these are the things you want to look for because it should be in plain and, as I said, unambiguous language that anybody should understand. Okay? So, basic requirements to ensure that your will is valid. The person must be 18 years of age or the age of majority unless he is privileged. Privilege not from a sense of coming from a good household or something. It's privilege if that person goes out to battle and a privileged will is made. Additionally, the testator, you as the testator, the person making the will, must have testamentary capacity. When we say testamentary capacity, it means mental capacity or having a sound mind when at 2 points. When you're making the will, as in when you sit down with your attorney and said, hey, Shazard, I want you to give the following items to the following persons. I can't take that from an insane person and then make that a valid will. And the second point in time, because some people make a will, they go back, they come back, they may think about it, but you must also have testamentary capacity, or what we call in Latin, animus testandi, when executing the will. So there are 2 points that you have to be of sound mind. And then there are certain legal requirements laid down by Section 60 of our Succession Act, and that is in accordance with the laws of Barbados. So those are the 3 things I want you to bear in mind when you're making a will, very basic requirements for your will. Now, for a will to be valid and to be admitted to probate, and probate is the formal process a will goes through the court before it is declared to be the valid will, is that firstly, it must be in writing. Now, obviously, you can't rely on saying hearsay evidence where we say, well, I heard John said that he wants to give his car to his son Jack and he wants to give his house to his wife Jill. That must be written down. And when we say written down, it may be handwritten, it typed. You could handwrite it yourself, you could write it in ink, you could write it with a pencil. And obviously, if you write something down to give it even further validity, you have to sign the will. So signing the will is important as the testator to give effect to a will. So think about it when we're going through is that you're looking at certain checkpoints and you're building on what you ought to be doing. So clear, unambiguous language, clear persons that you want to give the gifts to, and following certain formal requirements. Now, some people, you have some elderly folks may not be able to sign. Some people aren't able to write. And therefore, what constitutes a valid signature? In some instances, a thumbprint is a valid form of signature. The testator may have a special seal or a rubber stamp or even the initials of the testator. Ideally, yes, you would want a full, as we call it here, a wetting signature of the testator. But in the event, if there are circumstances where the testator cannot do that, the thumbprint stamp and with the thumbprint perhaps, or the initials would work. The court generally looked at um, in the estate of Cook, where a mom, the mother left, she handwritten a will, and at the end of the letter, she said, "Your loving mom." And the court inferred into that matter in the estate of Cook that "your loving mom" was a valid signature of the testator, and that was held to be a valid will in that instance. The important fact that the court will look at is whatever the mark of the testator puts on the will, it must be representative of his signature. So whatever it is you use, thumbprint, full signature, initials in a fancy whatever, how you do it, once it's your mark, that is something that you would want to have. Now, can someone other than the testator sign in his presence? Now, the Succession Act can provides for a will being signed for and on behalf of the testator by someone other than some other person in his presence and his direction. So perhaps the person is unable to sign for themselves for whatever reason, he can appoint somebody to sign on his behalf. And that needs to bear something that we met earlier up, which is the attestation side of things. Now, part of the formal requirements is that the act of signing must also be in the presence of witnesses. Now, two or more witnesses must actually see or have the opportunity of seeing the testator, or whether he directs somebody on his behalf to acknowledge his signature on the will. And these are important steps because these witnesses, should the will be challenged, may be called upon to give evidence should the matter become contentious. So it is important to have witnesses, and we see this in general practice where when you sign certain documents, you are required to sign it and have it in the presence of witnesses. So it's no different from when you are doing a will, because obviously dead man tell no tales. So your words and your last will and testament needs to speak for you and on behalf of you, but also the witnesses who signed in your presence would also be able to speak to your last will and testament. Now, I touched a bit when I said the attestation of witnesses. Now, after the testator signs, then the witnesses must then sign and attest in the presence of the testator. Now, as you're a witness to the testator, you can only sign after the testator has signed or acknowledged. You can't do it beforehand because you don't know. And there have been case law where testators, or not testators because they have already passed away, but challengers to a will say that, oh, well, the testator was unfairly, he was coerced, he was subject to undue influence when he signed the will. So it's important to have the witnesses sign in the presence of the testator, because these are the same person who will be called to give evidence, like I said, should the will become contentious and be before the court. Generally, probate matters are what we call non-contentious matters, in that nobody contests it. There's generally, it goes through formalities where you call in the estate, etc. But if it does become contentious, these are the safety mechanisms built in into the will to give some credence to what the testator signed. Now, along with um, you being competent as a testator, having mental competence and mental capacity, your witnesses need to be competent. And it's a common law rule. And when I say common law, meaning that it is established by case law, that no person under disability should act as a witness. And it should be noted from the case of Estate of Gibson that a blind man cannot be a competent witness. Um, Parliament recently passed legislation giving certain protections to persons with disabilities. Um, I don't know of any case law that has tested this um, common law principle or common law rule, but in just for the safety of it, subject to it being tested in a court of law, um, you would want somebody to be competent, and meaning generally without a disability, being a witness to you signing your will. All right. Now, this is something I want you to just keep in mind, put it in your front pocket, put it somewhere that your witness cannot benefit under the will. So, what you have here is that you cannot bring along your wife or your husband, as the case may be, or somebody who is going to benefit under your will, and say, well, witness me signing this will. And think about it. It's a very, it just makes sense, because if that will gives a benefit to this witness, and say, for instance, it gets challenged in a court of law by somebody else saying, well, no, you coerced my father or my mother to give you this. Obviously, the witness is going to say, well, yeah, he signed to that. He wanted me to have that benefit. So an attesting witness would obviously say, yes, he signed it at his own free will. No force, no coercion, nothing. So the law says that if you are a witness, you cannot be a beneficiary. And the language in Section 66 of the Succession Act says it will be utterly null and void. And I think the fact that the Succession Act says utterly sends a very strong message that the lawmakers had when they crafted the Succession Act, is that please do not give a benefit to your witness, or don't let anybody who is intended to benefit under the will be a witness, because it will be utterly null and void. Case law supports this point, where a daughter's signature at the back of a mother's will, where she signed under the witness. And although there were two other independent witnesses, the gift to her daughter under the will failed. And that sort of case law is supported in our legislation. So please bear that in mind when you are drafting a will, that your witness should not be a beneficiary. Give it to somebody else, the lawyer or anybody who is not a beneficiary under the will. Let them be a witness to you signing your will. Now, the testator, and we return to this nice Latin word here, says of the testator must have animus testandi. It's testamentary capacity, or you having the ability, or the test is the lack of it is the basis on which admissibility has been tested in court. Now, this requirement, and I call it a requirement because it has been given statutory force under Section 61B of the Succession Act, where the law says you must be of sound mind. If you look at the legislation, you'll see that it speaks to sound mind. Animus testandi is having sound mind. When you have animus testandi, you have to be able to make the will, or you have to have animus testandi, or have a sound mind, when at the point of making the will. You have to know and approve the contents of your will. And it must be that you are free and capable and having exercised your genuine effort, and there was no undue influence or fraud of anybody else taking somebody who, let's say there are case law where persons who have epileptic seizures, who, believe it or not, was in a coma, those who have um, any sort of mental disability and have them making a will on their own, that could be challenged. And if you cannot prove that you have a sound mind, or if there's evidence adduced to say that this person did not have the mental capacity to make the will could be rendered null and void. Now, every most of these things, as I was saying, that um, common law or case law drives a lot of the processes that we now have placed in the act. The case of Banks versus Goodfellow, um, a little background on that case is where the gentleman, and as you can appreciate, the age of the case is 1870. And the gentleman, John Banks, had a lot of assets, and he was also a schizophrenic, a manic schizophrenic to be exact, according to the law. And but he had moments of um, lucidity, and he had moments of being able to have and give clear instructions. And it was challenged. His will was challenged, and it was ordered and it was awarded that he did possess the mental capacity at the time when he did not have a seizure, because he gave the instructions, and at the making of the will he had the sound mind, sound disposing mind, as the case said, and memory. So he knew all the assets he had, and he knew what he wanted to give and whom he wanted to give it to. Now, it doesn't mean that the person has to be of be some sort of scholar or anything like that. That is not what having sound mind. It's just having sufficient intelligence to understand what you're doing and being able to say, well, I have X, Y, and Z, and therefore I know what I'm doing with my assets. So it is not something that is a high degree of um, a test or anything. It is just by the ordinary man's standard that you prove mental capacity or being of sound disposing mind. Now, what you have here is the testator must have testamentary capacity, where you have to give it at 2 points, which I did say, at the making of the will and at the point of time of signing the will, sorry. Now, you must be able, obviously, if you give your attorney, let's just say you go and instruct them on Monday, and you go back maybe a couple weeks after. Between that time, your attorney or somebody, if there's any form of fraud, not that I'm saying your attorney is going to commit fraud, but you have to be able to read what is before you and execute and say, oh, well, this is what I intended to sign. So that is why the law imputes a requirement on you, the testator, to have that sound mind when making the will and signing the will. And I want to pause here perhaps to take some questions.
Yes, Shazard, we do have one question so far in the chat from Skylar. She
Uh-huh.
is asking, is the disability mentioned include a physical disability like missing a limb or being deaf.
No, 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 no. The disability in this case, you see, it's the act of seeing um, the testator make and actually sign. So that is why the case law reference in Re Gibson spoke to more so a blind person not being able to do that. But people with a physical disability will not stop them. It is all about the bigger tests, I would say, to the person who asked the question is, you know, the mental capacity of the witness as well. They have to be of sound mind as well to understand that you are signing something to that effect. So a physical disability as missing a leg, one arm would not would not be of great contention.
Okay. Hopefully that answered the question for you, Skylar.
Yeah.
Before you move on, Shazard, before you were talking about when a person is signing a will that they have to have two witnesses. But what if
Yes.
there is a situation now that the two witnesses pass away?
Well, that is now that's a ticklish one because what the law allows is that you have an attestation clause. So ideally, there is some coverage that you would have had a recital and you would have had a provision included in the will that this person, let's say John Doe, would have seen the testator sign on so and so date at time. So um, you do have some sort of provision. I think Laquan, that's like a
Yeah.
real worst case scenario. Um, that you will have your two witnesses. Now it doesn't mean that it's limited to two. You can have three witnesses.
Okay.
But the key point, and I want to drive home to all our participants, is that if that witness, you having witnesses, please do not have them being a beneficiary under the will because then they will lose their benefit. That is a critical point. So you could have more than one witness, more than two witnesses, sorry. And ideally, hopefully, Laquan, that you don't have Murphy's Law kicking in where you have both your witnesses, and hopefully, it's not a will that ends up in contentious situations.
So basically you have backup witnesses technically.
Right. So you have the attestation clauses, you have provisions within the will that affidavit of due execution, that sort of thing is going to support that.
Okay, thank you, Shazar. And lastly, we have another question from Safaya, and
Sapphire,
she
yes.
is asking, how do you prepare for the event of the beneficiary being a minor?
Okay. Well, good question. And I'm going to address that lower down in my slides. So, Sophia, stay tuned for that one. I'll place a little more emphasis on that one for you.
Okay,
Okay.
yeah,
Right.
that was the last of our questions, and you can continue, Shazar.
All right. No problem. So, this is something, you don't have to, it's not something that is necessary that you learn or anything because as a layperson, don't stress your head too much about it. But I thought it would have been necessary just for your education because I always believe that once you are educated, you're empowered. So it's just to learn that your a testamentary gift, some definitions. You have a testamentary gift is anything that the property you intend to give to the beneficiary named in the will. A bequest is one of a personal nature, so a movable property. Um, that is where, let's just say, uh, your laptop, you have some sort of device. You call those a bequest. A legacy is often money, gift of money or monies in bank accounts. That is what you use. A device is real property, things that are immovable, fixed assets. And then you have a personal property, that again is movable property. And certain phrase you might describe your device as real property. So I give my real property, house located so and so, to whomever. So that is something, some terms that you may see pop up in a will when it's being drafted. But when I don't want you to be too worried about it, but when you are giving your instructions, be as clear as possible, be as descriptive as possible, and be as specific as possible. Now, when you're drafting the clauses in a will, I want you to pay special attention, because if you don't draft clearly, or when it is you give your instructions, let me don't say draft, although you could draft it on your own, um, you would want to make sure that a specific gift to a specific person is clear and unambiguous. So let's do some examples now. So I make the following special bequests. I give my BMW Mach 123 to my wife Shana if she survives me. So let's just say, as we used earlier, I give my BMW car to my wife. So we're taking off the word, the number plate MAC 123, and we're taking off Shania's name. And let's say you have two BMWs, and you have a wife, but then you divorce maybe Shania, and you married Jill. Now, what you have created there is a bit of ambiguity. You created a bit of confusion. And I mean, again, I keep saying dead man tell no tales. So nobody gonna come to wake you up to say, hey, could you tell us which BMW you want to give to your wife, and more so, which wife you're talking about? Your wife when you made this will, or was it somebody else, the other wife, the second wife? So a few things I want you to take out of that. You want to be as specific as possible. So you say, I give my BMW Mach 123 to my wife Shania, and then I give my BMW MA 125 to my ex-wife Jill. And that is how you want to make it gifts very clear. Now, the second point I'd make to everyone here, and this is something I wanted to address, is that when you are divorced and you say give to my wife and you remarry, the will now be null and void when it comes to that marriage, and it will now, the court will impute that you meant the wife of current. Now, this is why dating a will is so important, because it could be challenged. And usually when you're drafting a will, one of the very first thing you say is that I revoke my former wills or any of my former wills. And so this will be your current will. So every time you do a will, say you fall out with your good friend that you was going to give something to, and you do a fresh will, you revoke all the previous wills that you've done and you draft afresh. So some things like these, I want you to be very clear about that. Once you are drafting a will, you be as clear as possible with your specific gifts. Now, in a situation like this, what the court will do is that the court will introduce extrinsic evidence to aid the interpretation of the will. Well, what does that mean, Shazad? It is going to use external information or evidence from your witnesses. It is going to use maybe a marriage certificate. It's going to use the date that you made the will. And these are some of the things that the court is going to take a look at if it is that the will becomes contentious, because Shania and Jill are going to be fighting for the BMW if you just put Y. And if it is you have more than one BMW, or one is valued more than the other, they might fight over that. So be as specific as possible so you don't have fights. Now, again, I leave, this is another way you can phrase it. Oh, and Laquan, you put a really nice, and I want to thank Laquan for, um, sprucing up my very dry presentation by putting all these lovely pictures. So Laquan, thank you very much for it.
Yes, no, yep, no problem, Shazard. Mm.
So when you do specific devices, so I leave half share in my matrimonial home. Don't just leave it at that. Put in the address to my mother and my daughter and my son in equal shares. So you try to be as specific as possible. What if you have more than one daughter, you have more than one son? Be as specific as possible so you prevent any ambiguity. Remember, dead man, tell no tales. So your will has to speak for you. Now, it is important to know that when you say, I give my tangible personal property, so that's everything else other than your fixed assets, to my wife, Shania. If she does not survive me, so say the wife um, predecease or she dies, what you have to do is that will go on to my children who survive me in equal shares and to be divided by my executor. Now, one thing I focus a lot on the witnesses and I focus a lot on you drafting the will, but you must have an executor, which is a male, or executrix, female. You could have more than one executor. And as the name suggests, the executor is that person who will carry out the wishes that you may have in the will or that you will have in the will. Now, if you fail, if a gift fails, say these things are not clear or there's some problem with it, you have or you didn't cater for something that ended up forming part of your estate, we have what we call in a will a residual clause. Now, as the name suggests, it's a residuary, meaning that it's going to hold all the stuff, all the assets of your estate that you didn't cater for. These are some of the things that um, perhaps the gift would fail, or it failed because you sold the BMW or something like that, and it's no longer part of your assets. All of these, whatever you buy after that, say you buy the Mercedes and the Rolls Royce and whatever else, that goes into the residuary clause. Now, it's called a catch-all clause because you will want to have this catch-all clause. If you don't have a catch-all clause, it will be governed or distributed by the rules of intestacy. And what are the rules of intestacy? Certainly, in a nutshell, it means that the law will dictate how the gifts are going to go. So it will go either to your husband or wife, it'll go to your children, and it devolves accordingly. So the rules of intestacy basically is simply this. If you fail to make a will, the law will kick in and distribute your assets as it sees fit. And when I say how it sees fit, it'll give it to your next of kin, your husband, your wife. If you don't have a next of kin, it goes on to your children. If you don't have a children, it devolves. So the rules of intestacy flows if it is you don't have that residuary clause, or even if you don't have a will. Now, what does a residuary clause look like? So I hereby leave the residue of my estate, essentially what's left back, and after your debts and your funeral and your administrative expenses are paid off, to your sister, my sister Mary, if she survives me. And if she predeceases me, or if she dies before the testator and there's no more Mary in the picture, that will go to my children in equal shares. If you do not have a residuary clause, the rules of intestacy will set in, and the law will decide who will get the remainder of your estate and all your assets that were not gifted away in the body of the will. Now, this is where I believe Sophia was asking about for a minor. Now, a will doesn't stop at just simply saying, well, hey, these are all my assets. You all take it, go along, be happy, be merry, enjoy yourselves. You can direct your will up to the point of gifts to charities, your donation of your organs, your directions for burial. Because if you don't have that conversation with your family, they might say, well, let's bury the person, let's do a cremation in Coral Ridge, let's bury him somewhere else. And, you know, if you want that um, sort of direction, you put it in your will. Remember, this is a will is your last will and testament. It is your last closing words of what it is you want to do. And then again, I go back to the point of dead man tell no tales. So you may have had a conversation with your wife or your husband saying, well, I wish to be cremated and have my ashes scattered over the ocean. Then your kids might say, no, I don't want them, my mom or dad to be um, cremated and I want them to be buried. And there's a contention. So the easiest way to solve that is put it in the will as to what it is you want to do. So a will, I would say, is not something that you're going to have a singular thing. Sit down with your family, work it out, go through it. That comes to all of us. It's one of those things. Once we are born into this world, we have to go at some point and sit down with your family. As morbid as this conversation is, I think everyone here would appreciate it's better to have this in place than not have it, because you never could tell what contention arises after we depart this life. So other clauses could be some of these. And this is where Sophia is asking as well. In a minor situation, you could appoint a guardian, you can have a trustee, and in that trust instrument, which is a separate thing altogether, or it's created from the will, whereby you can leave a certain amount of money to the executor to hold in trust for the benefit of the minor. You could appoint a guardian as well. So you could say, well, okay, my sister or my brother will take care of my infant child, and have it as a backup, because you appoint your sister to be the sole guardian of your infant child until he or she reaches 18 years. Like I said, it's a gender neutral drafting. And if she predeceased me, the sister that is, and or unwilling to act, I appoint my mother as a sole guardian. So things like this, Sophia, that you can include in your will to direct for minors, and see how well they can, take care of it. Now, it is important, and I kept this presentation so far to be very, very broad, all encompassing, simply because I want to give you all a general sense of what would be a valid will versus what could invalidate your will. Now, like I said, generally, wills are what we call non-contentious matters, meaning that they do not go before a court of law to be decided upon. But sometimes will can become contentious. People lodge what they call caveats or warnings, or remember, you advertise, or for those who don't know, you advertise the will, um, and when you are doing the probate process, simply because you want to give opportunity to the public to say, if do you have a will that supersedes this? Do you have something that could challenge this? And then once that happens, then your will could become contentious. But always remember, when the court has to construe and decide and look at a will or try to ascertain the intentions of you, that will be looked at from the letters in black and white in the written document that is your will. So, what the court does not do is that they will not make a will for you. They will try to get the intention out of your words to give effect to it. So that is why I cannot emphasize enough the the importance of being clear when you're drafting your will and be as specific as possible when you're doing your will. Now, before I close and I open up the floor in terms of questions, um, I want you all to remember that the gift, whatever it may be, could fail for some of the following reasons. Now, again, I'll hammer home the point that a beneficiary of the will cannot be an attesting witness. Remember what the law said earlier up, the Succession Act says it will utterly null and void. So whoever is your attesting witnesses, please do not give to them anything in the will. Otherwise, the gift will fail. Now, if there's uncertainty in the beneficiary or the gift, it would fail. Example that we did earlier. I leave to my daughter my BMW car. Um, you have more than one BMW and you have more than one daughter. Or you have, you know, daughters and you have, or I leave my car and you have how many cars, which one you're leaving for who? So see the practicality in it is that what do you leave behind the court to decide? What if the daughters decide that, oh, well, I want the one for $1 million and give the youngest one the one for uh, $10,000? I'm just saying. So if it is there's uncertainty as to the beneficiary, who you intend to benefit from the gift, or the gift itself, the gift would fail. And it will go where? Anybody could remember where it goes? You could type it in the chat. Laquan, we have any takers for that one?
No, we don't have any takers.
Well, it goes in the residuary clause. So whatever fails ends up in the residuary clause. If the beneficiary disclaims the gift and said, well, oh, I don't want this gift, then the gift will fail or lapse. Again, it'll go to the residuary clause. Ademption is just a fancy word of saying that the gift no longer exists. You bought the house located at um, 5 Southridge and you bought something in on the West Coast and you specifically said in the gift, I give my house in 5 Southridge to my daughter, but the gift was sold in your lifetime, then the gift no longer exists, it's going to fail. Now, abatement is something that um, which I dealt with a bit earlier, and I want to just drive home the point that the estate firstly needs to clear its debts. Um, so therefore, if it is that you have statutory debts owing, or there are certain debts that were accumulated during the lifetime of the testator, those debts would have to be paid off. So let's say you have $1 million and you have $900,000 in debt, and you only have the remainder of it. You just have 100,000, and that 100,000, let's just say you gave $500,000 to your daughter. She can't get any of that. She'll only get what is remaining. And the last thing, if the gift is for it's against public policy or it's deemed to be illegal, such gifts will fail. So if I give um, my money to the production of methamphetamine, so I give my money to drug users for the purchase of drugs, illegal drugs, the law will say no, that gift cannot pass because it's illegal. And those are some of the reasons I left that one for last because I don't think anybody will be gifting illegal things out. But that is the gist of what happens, and that is some of the issues that may cause a gift to fail. And that, ladies and gentlemen, basically marks the end of my very short presentation on wills. And I like to thank everybody for your attention. And should there be any questions, I guess, Laquan, you could moderate and tell me how it goes from now.
Yes, thank you very, very much, Shazar, for your presentation. It was very informative and I thoroughly enjoyed the session and everyone else here, you can say, enjoyed it as well. Before we move on to the questions, what stuck with me is the proper drafting of wills and making sure that you're being specific as possible and making sure that when you draft the will, it goes through the core and you just don't write something on a piece of paper and put it under the bed.
Yeah,
And also the fact that a thumbprint can be used as a signature as well.
yes.
So right now we'll open up the floor to any questions that we have, and we do have a few questions so far in the chat. We
Yes.
have
I saw, yeah,
question from Skylar. She's asking, does one have to include one's life insurance policy or other types of insurance policies in one's will?
one's will, right? Okay, so we dealt with Miss Wilkinson's question, right? So yes, so to your question, now you can identify the insurance policies, but also remember that insurance policies generally, by default, lists the intended beneficiaries. So generally, speaking, your insurance policies do have a beneficiary, or it asks you to indicate who is the beneficiary. But there is no harm um, in having it there. But ideally, I would say make sure that the insurance policy reflects the beneficiary in that regard.
Okay, thank you, Shazard. Hopefully that clears things up for you, Skylar. We have a next question here from Kimar Holder, and
Mhm.
he is asking, can the executor of a will also be a beneficiary?
I would not know. Again, you treat the witness and the executor in the same manner. So that is not something that the law would allow. So best bet, keep your executors totally, just treat them the same way you treat your witnesses.
Thank you. We have
All
another
right,
question now from
Karen Drakes.
Karen Drix.
Yep.
Can you have more than
So
one copy of
I
your
am
will?
say that
Eh,
again. Right. So can you have more than one copy? Yes. So ideally, um, I would say now. Remember, and I understand where Karen is coming with this question. That in the event maybe perhaps it's destroyed, or you want to have multiple copies. Um, yes. Um, I would say just remember if there's any changes to that will, that you do put the same replacement copies in all the places that you would have. And the best, which kind of ties in with your other question, is where's the best place to store your will? Now, the
mhm.
best place to store your will would be at the probate registry at the Supreme Court. There is the probate section um, to lodge your will. It's usually placed in an envelope saying who is the testator, who is the executor, who is the witnesses, and you have your name there, and it is lodged at the probate registry. So I would say, Ms. Drakes, the best place would be at the registry and perhaps with your attorney.
Okay, thank you.
And if you are on, I am seeing here from Vicky Victor, if
Mm-hmm.
you are unable to have a lawyer draft, um, well, that's what this presentation was about. Just getting you to know what are some of the basic rules that um, you know you can use, and certain rules that you need to have um, to get your will done. It's some of the best ways that you can do it. The certain formalities, the succession act is there to guide you, and I would have shared some of those. Well, basically the requirements essentially to have your will being a valid one. And Dolores Marshall, can the attorney be a witness? Yes, of course. Just remember the key rule is that the witness cannot be a beneficiary. Otherwise, then if you wanted your attorney to benefit under your will, then if he signs or she signs as a witness, they would have lost that benefit. So remember that point. If you're a witness, you cannot be a beneficiary under the will.
Yeah, we have
All
another
right?
question from Skylar as well. She's asking if the person making the will has left instructions as to the care of an adult child who is not
Yes.
mentally competent, but that child's physical or mental state has deteriorated so much that the testator's instructions are no longer valid. Would these instructions continue as were made originally, or is there a way that appropriate changes can be made after that?
Okay. So ideally, when it is you create a will, you can give directions to have the person be appointed as a guardian and also as a trustee. Now, as Skylar was saying, in terms of the child being not mentally competent and the child physical and mental state has deteriorated, what you have to do is essentially put in that trust instrument that it is for the care of the child, their well being, and whether you want to include for future medical expenses, for their educational expenses. That is what you will have to draft to capture that sort of requirement because so Skylar, that is where you would have to take your mind to that if it is that the child was a minor at the point of making the will, and then, as you say, the guardian they become an adult. The trust, having a trust set up for the benefit of that child, who will eventually become an adult and maybe have the same issues. The best thing is to in that will allow for the creation of a trust. So the executor will then be acting as the executor and trustee.
Okay, thank you, Shazar. We have another question from Sophia. She's
Yes.
basically asking if there's no will, can you speak to the letters of administration?
All right. Right. So letters of administration is so you have basically two let's call them vehicles. You could either jump into the one of creating a will where you'll be given a grant of probate. Essentially, as we discussed earlier, Ms. Wilkinson, that you decide how um, you want your assets to be distributed upon your debt. So that means that the will give you a grant of probate. That's the road you go down. But if it is you fail to make a will, then how will the law know what was your intention? They can't. So then what is done is you have letters of administration. Letters of administration is where the law then steps in. The rules of what we call intestacy. So the opposite of testacy, which is when you make a will, is intestacy. So the law will say how your assets will be distributed. And it goes in a scale. I want to say a scale, but it goes down a totem pole, so to speak, or it go down a chain where they will give to your husband or wife. If there's no husband or wife, it will go to maybe a child. If there's no children, it goes to brothers and sisters. So the law will then impute what your intention was. And that is what letters of administration. So whoever somebody will have to then step in and say, well, the person died, but they didn't leave a will. So then you kind of go through the same process in terms of probating, but it will be with the intention of getting a grant of letters of administration, where then you would say intestacy will kick in and you put yourself forward as the executor. And well, it wouldn't be executor, but you are going to be in charge under letters of administrations rather than a grant of probate to distribute the assets accordingly to how the law um, basically describe and dictates how you do it. So those are the two different um, vehicles or the two different avenues you have. And ideally, I would say it is every intention or everyone's intention here to have a will, because you could very well give give it to. I mean, there were instances. I wanted to um, bring up some of them, but there was a very recent one where, and I'm sure it may have sparked some sort of media buzz, where I believe it's the owner of Louis Vuitton or one of these big fashion houses. And it was stated that he left all his estate to his gardener. So had he not made a will, leaving his $1 million, $1 billion fortune to his gardener, then the law would have stepped in and said, well, okay, Mr. Louis Vuitton or whoever his name is, um, it goes to your next of kin, it goes to your wife. If you don't have a wife, it goes to whoever, and you go down the pole. Or if you're disgruntled with everybody else, you can leave it to your dog and give it to your dog and put it on a trust. And you'll have a trust manager or your executor, your executrix, basically managing the money for the upkeep and benefit of the dog. So ideally, you would want a will to basically give effect to your intentions. So that is the crux of it, that you would want that sort of um, to give that sort of guidance on your debt. Remember, I said,
Okay.
dead man tell no tales.
hmm so I don't see any more questions in the chat, Shazard, but I do have two questions for you.
Sure.
I know persons may say, well, I don't really have much property, it don't really make any sense getting a will. Is it still important for them to get a will?
Yes. Remember when we discussed earlier on, I mean, a will doesn't just deal with your property, it deals with what your intentions are upon death. So you may not have assets, but let's just say, and I believe we do have an organ donor policy here, and you could actually sign up to be an organ donor. But you could give of yourself in a very physical sense. So you could devise and basically set out your last will and testament to give whatever little you may have to a charity. You could give direct how your funeral is going to be done. You could direct that your organs be donated for research or give it to somebody who needs a transplant. So I don't want people to address their minds to will being purely on your physical assets, as in your tangible, movable, or immovable assets. It could
Okay.
very well be that you just want to give directions to how. your body is going to be disposed of. And these are the kind of things that you can basically commit to a will if you so desire. Because somebody is going to do
Okay,
it for you.
thank
The
you,
state is
Shazard.
going to do it for you, or the law is going to do it for you. So it's either you want you to have that last say, so to speak, or you would let the law run its course.
Okay, my last question is, can a will be challenged in court, and if so, on what grounds?
All right. So a will could be challenged in a court of law, and the process of um, at least going through probate allows for the public to challenge or bring a challenge to your will. Um, the challenges that could arise, and that is something that we dealt with a bit earlier, where you have maybe warring um, children who may challenge the validity of the will or the contents of the will. So a will could be challenged on the ground of fraud, saying that this is not the last will and testament, it's not their valid signature, this is not the testator's mark. It could be challenged on the ground of undue influence, saying that the person was not of sound mind, they were in a coma when you make them put their thumbprint, and all these witnesses who may be perhaps going to benefit would say, so a will can be challenged. Um, it has been challenged in the past. The cases, even in Barbados, here wills have been challenged. You see it on the papers sometimes, um, where caveats are lodged, or basically what they call warnings that this probating or this probate that is going through or being initiated needs to be stopped because I have a challenge to the will. So a will could be challenged on many grounds. On the grounds of maybe a child comes in the picture, that you had an outside child, as they say, and the outside child comes now and said, well, I leave $1 million to my child or to my children. So the man or woman may have had a family of, say, 2 kids. And let's say somebody from the outside challenges and say, well, this is my father. And this is, I have to have a stake in this money or in the assets that the $1 million he's leaving to my children. I am one of his child. So then this outside child is going to say, you can't proceed to probate this will court, and they will now have to bring evidence. That's the extrinsic evidence I was speaking about. Maybe there's a birth certificate, maybe there are pictures, maybe they'll bring witnesses. I don't know. So it's how much this outside child is saying, all right. And I mean, I'm actually referring to actual cases that have happened where the law has decided there is nothing like an illegitimate child. Once they're a child, they will stand to benefit. What, and this will go back to Miss Wilkinson's question, if it is that you don't have a will, the law is simply going to say if you are a child of the testator, you will benefit. Whether you're the outside child or the inside child, if you get my drift. But um, that is what some of the ways in which wills can be challenged, and the court will allow extrinsic evidence. And it's better to have a will than to not have a will, because if you could recall how Lady Justice ought to be, she stands there blindfolded because she will not see an inside child or an outside child. She will just see a child. And once you're a child, then the scales of justice will say you stand to benefit as every other child of the testator.
Okay, thank you very, very much, Shazard. Seeing that we don't have any more questions,
I'm
um,
seeing, oh, wait, there's one question here by Miss Wilkinson. can a will that assigns a guardian take effect if the other parent is alive? Um, that is uh, is not something I would say could raise a bit of contention. It will have to remember, once a parent is alive, that parent and the court will impute that the child, if one parent passes away, the child, the other parent will automatically become, and I say automatically in a very loose sense, that the other parent can have an interest in the welfare of this child. So, what I'm saying to you, Sophia, is that whilst you may give a will that directs and assigns a guardian, should this parent have a legal interest, whether it be custody by a court order saying that they have joint custody, then you will have that parent will have access to this child. Now, you further went on to say that, and I'm saying this for the benefit, although I see it's a direct um, message, I just want to share it for the benefit of everyone that if they are not an active parents, once you assign the trustee, the other parent cannot access those funds, I'm presuming. Right. So the fund, as it should operate, is for the benefit, the sole use and benefit of this child. The guardian that you've appointed perhaps may act in your shoes. And when I say in your shoes, you can appoint this person as the guardian, and they can then fill your shoes and operate the trust as it ought to be for the benefit of the child, not discounting the rights and the legal entitlement of the other parent to access this child, or to have some sort of care and some sort of benefit or access, when I sorry, not benefit, but benefit of spending time with the child and that sort of thing. But if you devise a will, and you devise a trust for the benefit of this child in question, the law will give effect to that, and your will give effect to that for the sole use and benefit of the child. But like I said, we will have to, it's always important to be as specific as possible and as detailed as possible when you are drafting a will. And more so, as Miss Wilkinson, I sense that it is a very live topic for you, that you give it some thought. Speak to an attorney to see how best you can get this will as well as a trust going out of the will in benefit or for the benefit of this child. So I hope that sort of gives you some clarification, and for everybody else.
Mm.
So I
Okay.
really hope that everyone um, benefits from the this evening's discussion, and I hope it was useful in some form or fashion.
Yes. I'm seeing some compliments in the
Oh,
chat. People are definitely saying that it has been very informative and it was a great presentation.
thank you very much. I am seeing, oh, I don't want to deprive anybody else. I think I hope I answered everybody's question. Um, Thank you very much, Miss Drakes. And thank you guys. And remember, Affinity Plus, we're here to at least guide and support you all in the planning, because financial planning is important, and more so financial planning in a testamentary sense is also very useful.
Okay.
So thank you
Well,
guys.
yes,
Thank you
thank you
everyone.
very, very much everyone for coming out. And this is the end of our presentation.